I would say that, a newspaper article from Jim Jones doesn't overrule our Supreme Court, and that regarding the Blaine Amendment, it went to the same grave as Roe versus Wade, based on recent Supreme Court decisions. Those Supreme Court decisions that we hear mentioned, Espinoza versus Montana, the Montana Department of Revenue in 2020, and Carson versus Macon in 2022, and our Supreme Court was so clear on this, which just confirms that the Blaine Amendment, they said, is a violation of the First Amendment, specifically the free exercise clause. I think it's worth pointing out as well that former Attorney General Wasden agreed with this assessment last year when there was a similar school choice bill brought up. He said that using dollars in this way, I believe he said it was likely constitutional in his letter that he sent to the legislature. And our current Attorney General has also concurred with the Supreme Court, saying that the Blaine Amendment cannot be used to discriminate against sectarian organizations. So I think that's important to point out. And this, again, this is Justice Samuel Alito in one of these Supreme Court cases. I think this kind of puts the nail in the coffin. He said, named after House Speaker James Blaine, the congressman who introduced it in 1875, the amendment was prompted by prejudice against immigrants, particularly Catholic immigrants. In effect, the amendment would have barred any aid to Catholic and other sectarian schools. As noted in a publication from the United States Commission on Civil Rights, a prominent supporter of this ban was the Ku Klux Klan. The resulting wave of state laws withholding public aid from sectarian schools cannot be understood outside this context. So again, a newspaper article from Jim Jones I don't think overrides the Supreme Court on this, our former Attorney General, or our current Attorney General.